Hi, I'm Leonard Baines, Dean of the University of Houston Law Center. I want to welcome you to this CLE on the history of immigration. So the law school is a top-tier law school with several programs nationally ranked. And one of the things that we've done over the years is to make sure that we've had really robust conversations among experts on issues of the day. And today we're looking at immigration history. We study history so we don't repeat the mistakes of the past. About 100 years ago, the US had very harsh restrictive immigration policy. In terms of demographics, we're in a similar place to where we were about 100 years ago, with a larger percentage of the population being foreign born. Newsweek recently reported that the percentage of US residents born outside the US has reached its highest level in over 100 years. According to new data from the US Census, 14.3% of the population was foreign born in 2023, up from 13.9% in 2022. This is the largest share since 1910, when the figure was 14.7%. The rise is driven by international migration, which has become a key factor in US population growth. With fewer children being born in the US, immigrants now account for over 2/3 of the country's population increase. The biggest growth in immigration came from Latin America. In 2023, Latin Americans made up 51.2% of foreign-born population, up from 50.3% in the previous year. In contrast, the shares of immigrants from Europe and Asia declined slightly. The number of U.S. residents identifying as Hispanic increased to 19.4% in 2023, up from 19.1% the previous year. Non-Hispanic whites dropped from 57.7 to 57.1, and share of Black residents remained steady at 12.1, while the Asians increased slightly to 6%. Meanwhile, the survey found that the U.S. population is aging. The median age is 39.2 in 2023, as baby boomers become senior citizens. And what we've seen is increased enforcement. The administration has declared a national emergency at the southern border, has prioritized aggressive enforcement actions, including military deployments. New daily arrest quotas and expanded expedited removal authority have led to increased interior enforcement and faster pace of removals. This reduced humanitarian pathways. Several humanitarian programs, such as Central American Minors Program, Family Unification Parole, and Safe Mobility Offices, have been terminated. There's been also restrictions on legal immigrations. Action have been taken to restrict regular immigration pathways, including aggressive vetting standards and plans for a new travel ban. An effort to end birthright citizenship for children of undocumented immigrants is in the courts, and recently the court has ruled that at least you can have a nationwide injunction with respect to that. This may increase fees and reduce support services for immigrants. Language to describe immigrants has been particularly harsh, and there's been erosion of constitutional rights of immigrants when it comes to due process. Let me show you this chart. This sort of identifies how the immigration, the number of foreign-born folks have changed over the past 100 years or so, basically. Let's see if I get back into it. Can you all see that? So you can see this chart from 1850.
Dean, we're not able to see the
You're
slide.
not seeing it. Okay, let's see. Can you put it up? Because I'm having trouble.
Sandra, could you assist the dean?
I'm getting it up.
Okay, thank you. I'm not sure what's happening.
Okay.
Can you see that now?
It was coming up.
Okay, wait a second. Let me try again.
Yes, we can see it now.
Great. Okay, thanks. Let's share from the beginning. So this chart shows over 150 or more years the percent of the population that's been foreign born in the United States. You can see there was an incredible increase around the beginning of the end of the 1800s and beginning of the 1900s, and then it dropped. And our panelists, our expert panelists, will talk a little bit about why it dropped, because there was very large enforcement of and anti-immigration policies during that period of time. It reached its nadir in about 1970, and the 65 Act, the Immigration Act, really opened up immigration, and now immigration has expanded. And you can see that we're sort of at the same peak. And so what we see is history is kind of repeating itself. I'm not saying that I'm saying there's a good thing or a bad thing. I'm just observing sort of where the percent of the population was foreign born back over 100 years ago and where it is now. And we see sort of similar behaviors and policies to restrict immigration because of that. So I'd like to now introduce our first panelists. We'll be introducing them in order of their presentation. And then each will speak for about 20-ish or minutes, including me. I'll be a panelist. And then we'll have a roundtable discussion at the end. So our first panelist is Kevin Kenny. Kenny is the Glucksman Professor of History at New York University. He received his PhD in U.S. history from Columbia University. His books include Making a Sense of Molly Maguire's, The American Irish, A History, Peaceable Kingdom Loss, The Paxton Boys, and The Destruction of William Penn's Holy Experiment, and Diaspora, A Short Introduction, and most recently, The Problem of Immigration in a Slave-Holding Republic, which he's going to talk about today. And so let's welcome Professor Kenny. Thank you, Professor Kenny, for being with us.
Thank you, Dean Baines. And thank you to the Law Centre for the invitation to participate in today's program, and in particular to Christina van Orsdal for her work in organising this panel. So, as we know, the federal government controls immigration today in the sense of deciding who to admit, exclude, or remove from the country. And yet, in the century after the American Revolution, Congress played only a very limited role in regulating immigration. Until the 1870s, the states patrolled mobility within and across their borders and set their own controls for community membership. A national immigration policy began to emerge only during the Civil War and Reconstruction, and that timing was no coincidence. The central claim I want to present to you today is that the existence, abolition, and legacies of slavery shaped American immigration policy as that policy moved from the local to the national level over the course of the 19th century. So I'm going to talk to you for 20 minutes. I'm going to do it the old-fashioned way without slides. I'm going to make 5 points to develop this argument. The first point has to do with federal control over mobility before the Civil War. Second point, what the Constitution says about immigration. Thirdly, the impact of the Civil War and Reconstruction. Fourthly, Chinese exclusion and the emergence of what we call federal plenary power over immigration. And finally, and briefly, some of the implications for immigration federalism in the United States today. So let me start with that first point, the extent to which the federal government did control mobility before the Civil War. Did not control immigration in the sense that we're using it here. It did control 3 other kinds of population movement that intersected with immigration in important ways. These were the return of fugitive slaves, the removal of free Black people overseas, and the expulsion of Native Americans to the continent's interior. So firstly, the Fugitive Slave Clause of the US Constitution required that persons, quote, held to service who escaped from bondage must, quote, be delivered up on claim of the party to whom such service or labor may be due. Congress acted on that power to pass legislation, the first fugitive slave law in 1793. In 1842, in the case of Prigg versus Pennsylvania, the Supreme Court ruled that the federal statute took precedence over a state law in Pennsylvania that made it a felony to remove, quote, any Negro or mulatto with a view to enslaving them. Northern states responded to this ruling by passing more stringent personal liberty laws to protect free Black people and escaped slaves. Southern slaveholders, who wanted the federal government out of their affairs in most respects, demanded stronger federal legislation to secure their property rights in humans. Congress responded with the sweeping Fugitive Slave Act in 1850 that allowed enslavers or their agents to arrest suspected fugitives, take them before a wide range of officials who issued certificates of removal, and no fugitive was allowed to testify in any trial or hearing under this law. So with its system of forced and arbitrary removal and its lack of due process or judicial oversight, the Fugitive Slave Act of 1850 prefigured some of the mechanisms for deporting immigrants introduced at the federal level in the postbellum era. Second area where the federal government was involved in migration was the removal of free African Americans overseas. Some left voluntarily for Haiti, Canada, or Africa, but most were removed through the so-called colonization movement. Colonization was not emigration. Even when voluntary, its purpose was to expel free Black people on the grounds that they could never achieve civil or political equality in the United States. In other words, the colonization movement was a form of social engineering based on race that led to the transportation of about 11,000 people, most of them formerly enslaved, to Liberia. Some African Americans initially saw advantages in voluntary departure, and none supported compulsory removal. Thirdly, the federal government forcibly relocated Native Americans. The Indian Removal Act of 1830 created the machinery that expelled more than 80,000 people from the southeast to locations beyond the Mississippi River. That's a form of deportation. For a moment, it looked as though Chief Justice John Marshall might halt the process. In Worcester v. Georgia, a case in 1832, Marshall defined Native American nations as distinct independent political communities, quote, distinct independent political communities, subject to the jurisdiction of the federal government, but not that of the states. But Marshall's decision did nothing to prevent the expulsion of Native Americans from their homelands in the Trail of Tears. 14 years later, in a case called United States versus Rogers, Roger Taney's court rejected Marshall's position, ruling that Native tribes were not sovereign communities, but rather collections of individuals bound together by race, endowed only with those rights the federal government chose to confer on them, and certainly not how the Cherokees saw themselves as a sovereign political community. These two principles, tribal autonomy versus minority status, operated in uneasy tension until the 1870s, when Congress discontinued the practice of making treaties with native tribes and nations. The Rogers decision, 1846, gave Congress a plenary power largely immune from judicial review, laying the groundwork for immigration policy as well as Native American policy in the postbellum era. Okay, my second point, the Constitution and immigration. Strangely, for a country that attracted so many immigrants, the Constitution says nothing about their admission, exclusion, or expulsion. The sole provision in the Constitution concerning immigration has to do with the naturalization of foreigners after they arrive. Congress duly passed laws stipulating a waiting period, proof of good character, and an oath of allegiance, but restricted this policy to, quote, free white persons. People of African origin could not naturalize until 1870. Asian immigrants could not become citizens until the 1940s and 1950s. Now, if you look for authority over immigration beyond that in the Constitution, you can look in a few different places. You can look at the taxing and spending clause, which arguably will provide some grounds. You can look at the war powers clause, which is back in the news. In the 19th century, the treaty power clause was important. Throughout that century, the executive branch pursued immigration policy through diplomacy, for example, with Britain and China. But the most important part of the Constitution in the 19th century, when it came to immigration, was the Commerce Clause. The Commerce Clause gave Congress the power, quote, to regulate commerce with foreign nations and among the several states and with the Indian tribes. Under a temporary qualification to this power, Congress was prevented from prohibiting the external slave trade for 20 years. It's one of several provisions by which the Constitution both recognized and protected the institution of slavery. Congress couldn't act against the external slave trade until 1808. To what extent, however, did the commerce power or the migration and importation clause, which is the qualification, to what extent did that power apply to immigration or to other forms of mobility at this time, including the movement of free Black people and the internal slave trade? This is a huge question throughout the first half of the 19th century. Under the Constitution, each state retained sovereignty over matters on which it had not surrendered power to the national government, including mobility within and across its borders. Towns and states used what was known as their police power to regulate admissions and expulsions, along with the health, safety, morals, and welfare of their residents, in line with what they defined as the public good. They passed laws that quarantined sick passengers, that required ship captains to post bonds or pay taxes for foreign paupers and other passengers who might require public support, laws that patrolled the movement of free and enslaved Black people, including free Black sailors who visited southern ports and were jailed for the duration of their stay. The constitutional battle over mobility and immigration in the 19th century pitted federal commerce power against local police power. Which level of government had authority, local or national? The courts were unable to resolve this question before the Civil War. If the Supreme Court invalidated state laws imposing taxes or bonds on foreign paupers, say in New York or Massachusetts, well, what about similar laws punishing free Black seamen arriving in Charleston, South Carolina, or laws in southern states expelling emancipated slaves, or laws in both the North and the South barring the entry of free Black people? It took a civil war to remove the constitutional and political obstacles to a national immigration policy. And that takes me to my third point, the impact of the Civil War and Reconstruction on American immigration history. The secession of 11 states from the Union, followed by the abolition of slavery, removed the political and constitutional obstacles to a national immigration policy. Yet it would be a mistake to think that in the absence of slavery, say if slavery had been removed a generation or two earlier, Congress would have stepped in and regulated, let alone restricted, immigration earlier, because that immigration was largely, almost exclusively European. Following the example set by the states, Congress might have excluded vulnerable newcomers, just as it did when it passed the first General Immigration Act in 1882. But nobody before the end of the 19th century, not even the know-nothings, wanted to restrict European immigration numerically. Many people didn't like the Irish, but nobody was calling for numerical restriction. Some nativists in the antebellum era called on Congress to extend the waiting period for naturalization from 5 to 21 years, or to regulate migration by paupers, but to no avail. Congress took no action before the Civil War, and admission was the norm for European immigrants. It remained so until the 1920s. So, even though the abolition of slavery made the emergence of a national immigration policy possible, it did not make that policy inevitable. There had to be some other historical contingency, and that contingency was the arrival in the United States during this critical period of large numbers of laborers from China. Chinese immigration took a wide variety of forms, but restrictionists came to describe all Chinese migrant workers as coolies, by which they meant a degraded class of unfree workers who, they insisted, should be excluded from the United States. A twisted reading of the 13th Amendment abolishing slavery produced the following syllogism. All coolies were slaves, which they weren't. All Chinese laborers were coolies, which again they weren't. Therefore, Chinese laborers must be excluded from the United States. Legislation in the 1870s and 1880s rested on this distorted anti-slavery logic with a particular emphasis on gender and class. So overall, Reconstruction had a double-edged impact on immigration. The Civil Rights Acts, I should say, and the 14th Amendment equipped not just citizens, but persons, including unnaturalized immigrants, with federally protected rights to due process, to equal protection. Under the principle of birthright citizenship, moreover, the American-born children of all of these immigrants were automatically citizens of the United States. These egalitarian developments generated a racial backlash. Politicians in the American West, aware that the new national state that had emerged after the Civil War could regulate and exclude immigrants much more effectively than any individual state, pressured Congress to act. The result was the Page Act of 1875, prohibiting the entry of Chinese prostitutes, and the Chinese Exclusion Act of 1882, prohibiting the entry of Chinese laborers. These are the first major steps in the transition from local to federal control over immigration. Interestingly, these anti-Chinese measures at the national level had precedents in the antebellum South, where free Black people were required to register to demonstrate their status and their entitlement to residency. They had to carry papers and produce them on demand. They could be banished for certain offenses. They were often denied re-entry if they left their states. Okay, fourth point, Chinese exclusion and the emergence of what we refer to in a shorthand term as plenary power over immigration. Chinese laborers were excluded in 1882. They could return if they carried valid certificates. These certificates were unilaterally discontinued by the Scott Act in 1888, leaving large numbers of Chinese laborers stranded. When they returned to the United States, they were denied re-entry. One of these laborers, his name was Che Chan-ping, filed suit claiming that he had a vested right to live in the United States. He'd lived there since 1875. He claimed he was being expelled without due process. In the so-called Chinese exclusion case of 1889, the Supreme Court ruled that Che's residency was a privilege, not a right, and that authority over immigrant admissions was inherent in the sovereignty of the United States as a matter of national security. The court allocated to the legislature and the executive, the so-called political branches of government, a plenary power over immigration, largely immune from judicial review. If that sounds familiar, it is familiar. The Supreme Court in upholding the so-called travel ban in the first Trump administration directly cited the Chinese exclusion case. All right, my final point today, I just want to touch briefly on the continuing importance of some of these issues in a federal republic today in the context of what we call immigration federalism. And I imagine we'll get into a discussion of this later today. The federal government has controlled immigrant admissions and expulsions since the late 19th century. But states, counties, and cities continue to regulate the lives of immigrants after they have entered the country, using their police power to do so. Police power didn't go away, even as the balance of power tilted during Reconstruction. And clearly, states and local jurisdictions play a double-edged role in this respect, depending on their location and their politics. Many local authorities today monitor, punish, and deter immigrants, support federal immigration policies, and cooperate with national agencies such as ICE. Others, however, pass pro-immigrant laws, facilitating, for example, access to benefits, education, and work. Some provide sanctuary against federal surveillance, complementing grassroots efforts by faith-based organizations and other activists. States cannot violate federal law, but neither can they be forced to implement that law. There's at least a partial parallel here with the antebellum era, when, as I mentioned, northern states passed personal liberty laws providing refuge for fugitive slaves and for free Black people in danger of being kidnapped into slavery. Local jurisdictions today can provide protection to vulnerable immigrants. They can refuse to act as agents of federal immigration enforcement. Local sovereignty understood in this way, then, is not simply a matter of autonomy from the federal government. It can also entail an obligation to protect all people living in a given jurisdiction, regardless of their background or origin, to enhance the general welfare and the public good. Now, obviously, given the long association of states' rights with racism in US history, local sovereignty is a thin reed on which to base a progressive politics. Rights can be protected much more effectively if defined nationally and guaranteed by the federal government. Yet, at times when the federal government is itself virulently anti-immigrant, cities, counties, and states can still play a vitally important role. Thank you.
Dean, we can't hear you.
Sorry. It's a great way to start this conversation. So thank you for your presentation. Now I have the great fortune to introduce the next panelist, Professor Jack Chin. So Jack Chin and I go back quite some time. We had been on the same faculty for a while when we were both much younger and had much darker hair. He's a teacher and scholar of immigration law, criminal procedure, and race in the law. His scholarship appeared in major law journals such as Penn, UCLA, Cornell, Harvard Civil Rights and Civil Liberties, Law Reviews, and Yale, Duke, Georgetown Law Journals, among many others. The U.S. Supreme Court has cited his work on collateral consequences of criminal conviction in Chavez versus the United States, in which the court called his Cornell Law Review article the principal scholarly article on this subject. And he was also cited by the Supreme Court in Padilla versus Kentucky, which agreed with his contention of that the Sixth Amendment required defense counsel to advise clients about potential deportation consequences of guilty pleas. Justice Sotomayor cited his Penn Law Review article in her dissent in Utah versus Strife. He teaches criminal law, criminal procedure, immigration, and he's director of the Clinical Legal Education Program at the University of California, Davis School of Law. Let's welcome Mr. Jack Chin, who's going to talk a little bit about Asian American immigration history. Thank you, Jack.
Thank you so much, Dean Baines, for the invitation. I'd like to thank everyone else at the University of Houston for the opportunity to talk about this subject. Can you see my slide?
Yes, we can see it, Professor Chin. Oh,
Great.
it looks like it's on your we can see the desktop. Yes, now, perfect.
Okay. So I'm going to talk about some of the very same things that Professor Kenny talked about with a slightly different emphasis. I'm going to make two propositions to you that I hope to demonstrate in this talk today. One is that exclusion of Asian immigrants from the United States was one of the longest-lived and most effective public policy initiatives ever undertaken by the nation. The United States calls itself a nation of immigrants, and that is, I think, true. We have a very large number of potential Asian immigrants to the United States because about half the world's population is Asian. Nevertheless, as late as 1960, after 150 years of immigration, the Asian population of the United States was about 0.5%. Insignificant. That was no coincidence. The other thing that I would like to suggest to you is that as part of the civil rights revolution of the mid-1960s, the policy of excluding Asians from the United States was eliminated through the Immigration and Nationality Act amendments of 1965. And I submit to you that that was one of the most effective civil rights reforms ever to take place in the United States. As you've heard, before 1965, about 80% of the immigration to the United States was of European descent. Since 1965, with no affirmative action, with no preferences for any particular country, something like 80% of the immigration has been from the third world. So, as Professor Kenny said, for much of US history, there were no federal immigration controls. And the state immigration controls existed, but they didn't exclude 5 or 10 or 30% of the people who tried to come. It was a very small number of the people who tried to come here who were excluded. In 1852, the Supreme Court could say, we have open borders. And there was some truth to that. However, this is not to say that the federal government did nothing to encourage or discourage immigration. One of the first things that the first Congress did was to pass a naturalization law. This was a complaint in the Declaration of Independence that King George III wouldn't allow naturalization, wouldn't allow encouragement of immigration to the United States. And the federal government wanted to change that. So it passed a naturalization law limited to free white persons. Now, this was understood to be and operated as an immigration law. And the reason wasn't that potential immigrants to the United States were really concerned about voting or being on the school board or political freedom. No, that wasn't irrelevant, but they wanted to be able to become citizens of the United States so they could own land. The law in England, the law in the colonies, the law in the early United States, at least in many of the states, was that you had to be a citizen to own land. And people wouldn't come here if they couldn't own land because agriculture was such an important part of the economy at the time. And so only white immigrants could participate in that for the most part, and other immigrants were excluded. So the Oregon Constitution, for example, other constitutions prohibited certain groups of people from owning land to discourage their immigration. And so in these early years of the United States, we have very clear explanations of the national policy. So Justice Greer, in an early immigration case, where they struck down the ability of states to tax immigrants, the Justice Greer voted the way that he did to strike down the tax because it would interfere under the Commerce Clause, as Professor Kenny mentioned, with the federal policy to encourage Christian foreigners of our own race to come and engage in productive agriculture. The Supreme Court, there's very little question that the Naturalization Act of 1790, when it limited naturalization to free white persons, was principally aimed at limiting the naturalization of persons of African descent and Indians. There were basically no Asians in the United States at the time, and so they weren't targeted by it. Years later, the Supreme Court would say they're covered by it because the point wasn't, in an originalist sense, to deny naturalization to Indians and persons of African ancestry. Instead, it was to restrict the privilege of naturalization to white people. Everybody else was excluded. It was a blanket exclusion. I think the conceptualization of Asians as excluded from the group of people who were encouraged to come to the United States comes earlier. I hope all of you are familiar with the Dred Scott decision. In 1857, the Chief Justice at the time, Chief Justice Taney, famously held that African Americans, whether born in the United States or born overseas, could never be citizens by birthright or by naturalization because of their status in society. One of the reasons that he relied on for that was the 1790 Naturalization Act, which he said makes clear that white people alone constituted the sovereignty in government. But Chief Justice Taney had a decision that was similar to Dred Scott, but it dealt with Asians. And he issued that decision 17 years earlier in 1840, when he was trying a case on circuit. So in those days, the justices of the Supreme Court not only decided the big cases that went to the Supreme Court, but they were also required to try cases, sitting as trial judges. And he went back to his home state of Maryland and tried a murder case, United States versus Dow, which involved a Filipino. And this is, I think, the first case that really dealt with the status of Asians in society. And Lorenzo Dow, the defendant in this case, was a Christian from Manila. And in those days, there were different rules of evidence depending on your race. And Lorenzo Dow wanted the rules of evidence that were applicable to white persons, to white Christians. They were more advantageous to him in the particular case. That's what he wanted. He raised that issue in the court, and Chief Justice Taney said, no, you may be a Christian, but you're not white. And as early as 1840, Chief Justice Taney was prepared to say that the colonists only wanted to invite white people from Europe to come to the colony. Other people were not welcome. And the reason being that the only nations of the world which were then regarded, or perhaps entitled to be regarded as civilized, were the white Christian nations of Europe. And certainly immigrants were not expected or desired from any other quarter. So well before the Civil War, Asians were fit into this racial regime that had been established for Africans and Indians. Now, we are told, I learned in law school, I read in the Supreme Court cases, that Reconstruction completely changed the racial status of people in the United States, that the purpose of the 13th, 14th, and 15th Amendments in the Associated Civil Rights Act was to do away with all governmentally imposed discrimination based on race. The 14th Amendment views racial bigotry as an evil to be stamped out, not an excuse for perpetual racial tinkering by the state. This, unfortunately, is not true. If you look at the details of what Congress did, what the states did when they amended the Constitution, it was not to do away with all governmentally imposed discrimination on the basis of race. One illustration of this is the failure of Massachusetts Senator Charles Sumner, who was one of the primary architects of Reconstruction. He certainly got a lot done, but it didn't go as far as he wanted it to go. He wanted to make suffrage, voting, and naturalization, the ability of immigrants to become citizens, completely race neutral, and that failed. So in a series of proposals, he tried to get the free white part of the Naturalization Act of 1790 removed. And on no less than 4 separate occasions, Congress voted on that issue, and they voted against it. And the reason they voted against it was because the Western states and territories objected to the possibility of naturalizing certain non-whites, in particular Chinese. There was a proposal to allow persons of African nativity and descent to naturalize, and that passed by 1 vote in the Senate. So there was a liberalization of the ability to naturalize in 1870, but by no means was the racial restriction stamped out entirely. The 15th Amendment also, which prohibits racial discrimination in voting, is also, I am sorry to tell you, a Jim Crow law. Because once again, Charles Sumner said, why don't we just prohibit discrimination in voting, period? Why limit it to citizens? And that was voted down, shouted down, really. And so the 15th Amendment is restricted to citizens, and that was designed to leave room for a certain kind of discrimination, racial discrimination. And that discrimination was this. Between 1795 and 1952, in order to be naturalized, an immigrant had to first file a declaration of intent to naturalize. And a declarant, a person who filed such a declaration, would be deemed a declarant alien, an intending citizen. There were various terms for it, but it was a recognized legal status. There was an elaborate jurisprudence of when a declaration of intent was valid or not valid. Clearly, someone who was disabled from becoming a naturalized citizen could not file a valid declaration of intent. And many states and territories enfranchised declarants. That is to say, they wanted to be able to let white immigrants vote without becoming citizens, but they didn't want to let non-white immigrants vote. So we see it was designed, therefore, to uphold provisions like this from the Idaho Constitution that prohibited Chinese or persons of Mongolian descent or Indians not taxed from voting, serving as jurors, or holding any civil office, perfectly legal under the 15th Amendment. And that was the very point. Declarants and free white persons were also able to own land under the laws passed by many states, taking advantage of the original purpose of the racial restrictions on naturalization. The states, including Texas, allowed white immigrants, but not others, to own land. So following the Reconstruction, there were a series of increasingly comprehensive laws restricting Asian immigration. Before the Civil War, before Reconstruction, we have the Cooley Act, the invention of the visa, I believe. Ships leaving from Asia coming to the United States had to get clearance from a U.S. consulate, otherwise they're not allowed to land. The Page Act that Professor Kenny discussed, a series of increasingly strict and increasingly comprehensive Asian exclusion laws, culminating in 1924, where Congress determined that if you're not racially eligible to naturalize, you're not racially eligible to immigrate at all. So we have a incredibly successful comprehensive policy of excluding Asians from the United States, which I said, as I said, left very, very few Asians as part of the US population. That policy ended in 1965. Why? Well, the reason is essentially the civil rights movement. The laws on naturalization are increasingly relaxed in the 40s and 50s, and ultimately race is eliminated as a basis for restriction in immigration law in 1965. And as legal scholars like Mary Duziak and Derek Bell explain, the reason is essentially geopolitics. And that's one of them anyway. And it starts with Dean Acheson, who between his service as Undersecretary of State and Secretary of State when he was in private practice, files a couple of briefs that would set in the late 1940s that would set a precedent throughout the 1950s and 60s, where leading lawyers and ultimately the Justice Department tell the Supreme Court, listen, we are in a struggle for national survival with an enemy, the USSR, that is accusing the United States of being racist. And we are trying to obtain the loyalty of people in the third world, while the USSR is saying, the United States doesn't like you. We have hot wars in Korea, in Vietnam, and the people in those places are being told, you are treated as inferior by the United States. Why would you want the United States to be on your side? So people like Dean Acheson and later leaders in the Justice Department tell the Supreme Court it's very important that that we send the right message about the law and values of the United States. And that worked. It was not that the public at large thought that immigration restriction was wrong. In 1965, when the racial restrictions were taken out of the law, public polling suggested that most people didn't support immigration reform, most average people. And they certainly didn't want more Asians to come to the United States. They preferred Canadian and English immigration, just as Justice Greer and the other and Chief Justice Taney and the other justices who believed that that immigration should be race-based had said. But the elites, the Supreme Court, the administration, members of Congress, thought that civil rights reform was important, so they pushed it through. The last thing I'll say is that there's a set of arguments that immigration reform was a fig leaf, that it wasn't actually intended to change the demographics of the immigrant stream in the way that it has. And I don't believe that. it wasn't purely a public relations measure or a foreign policy measure. And the reason that I believe that, I don't know if you can see this, is that I did a study with a law professor named Doug Spencer, and we looked at the overlap between the Civil Rights Act of 1964, the Voting Rights Act of 1965, and the Immigration and Nationality Act amendments of 1965. And we found that there was an extreme overlap of all of the bills that were voted on in the House and the Senate. These had basically the most overlap of those who opposed and those who supported these particular bills. In the House, in the Senate, overall, they basically had the same supporters and the same enemies. And so I think that that in addition to the geopolitical concerns, if you believe that the Civil Rights Act and the Voting Rights Act were intended to actually change the status of people in the United States and the rights and opportunities of people in the United States, then I think that you have to think the same thing about the Immigration Act, unless your view is that the members of the House and Senate who supported these reforms were hypocritical, which I don't. I think that the people who voted for it actually thought that the time had come to get rid of race as a principal basis for public policy in the United States. Thank you very much.
Thank you. Jack, can you pull down your screen? Thank you. So thank you, Professor Chin. That was wonderful. I'd like next to introduce our next panelist, who's Brian Edward Stone, who's a professor of history at Del Mar College in Corpus Christi. He's an award-winning community college professor at Del Mar College in Corpus Christi, where he teaches courses in U.S. history. He was named a 2024 Piper Professor by Professor Minnie Stevens Piper Foundation, which recognizes Texas College University faculty annually. He has also received the 2024 Western Regional Teaching Award from the Association of Community College Trustees, the 2021 Teacher of Year Award from Del Mar College, and the 2019 Del Mar College Eileen Creighton Award for Teaching Excellence. His latest book is Neither Fish Nor Fowl, a mercantile Jewish family on the Rio Grande. It's edited memoir of Morris S. Riskind of Eagle Pass, Texas. Brian is the author of The Chosen Folks, Jews on the Frontiers of Texas, which won the Southern Jewish Historical Society Book Prize in 2011. And he's the editor of the Alexander Gurwitz historical memoir, Memories of Two Generations, A Yiddish Life in Russia and Texas. Let's welcome Professor Stone, who's going to talk about Jewish immigration, specifically to our great state of Texas. Welcome, Professor Stone.
Thank you, Dean. I appreciate that. Thank you all for being here. I want to also thank the University of Houston and the Law Center for the invitation to participate. This is obviously a very important and a very timely subject, and I'm very glad to be here to talk about it. As the Dean indicated, I'm primarily a historian of Texas Jewish history. I'm not an immigration historian per se, but immigration is a huge part of what I do, and in particular, a specific subject known as the Galveston movement or the Galveston immigration movement, which is mostly what I'll be talking about today. The Galveston movement was an effort in the early 20th century, beginning in 1907, to divert the flow of Jewish immigration to New York, from New York to Galveston.
Professor Stone, you've
Specific-
frozen.
I'm sorry?
You had frozen. It looks like you're back
Oh,
now.
am I back? Good. Okay,
Yes.
thank you. The Galveston movement is a An interesting subject. It is, I think, kind of unique in that it's an organized national effort in regard to immigration. It was a community of people already in the United States seeking not only to facilitate immigration for their particular cultural group, but to try to influence legislation. They were concerned about immigration restriction, particularly as it might apply to Eastern European Jews. And they hoped that by kind of taking some control over where immigrants came, where they were settled, and how they got along, they might be able to discourage Congress from restricting that immigration more further. To start us out here, a little bit of background just kind of on Jewish immigration to the U.S. in general, a little bit of context. There has been immigration of European Jews to the U.S. Since there was a U.S. and even before. The first to arrive came during the colonial era. The first group to arrive in New York arrived in New York City in 1654. By the American Revolution, there were 5 Jewish congregations in the U.S. or in the 13 colonies, all in coastal cities in the 13 colonies. By 1820, there were still, though, only about 3,000 Jewish residents of the United States. 3,000. So it's really a very small population, a very small community. That changed with the second wave, so-called second wave of Jewish immigration, which began in 1820. Between 1820 and 1880, about 250,000 Jewish immigrants came, mostly from Central Europe. They're mostly from Germany, Austria, Alsace-Lorraine, and Poland. And one of the sort of characteristics of this group is how much they dispersed. They spread throughout the country. They kind of took advantage of westward migration going on at that time. They went out into the frontier, and they settled in small towns as well as large cities all through the country. By the Civil War, there were about 160 organized Jewish communities in the United States from coast to coast. This group of immigrants found, by and large, a niche, an economic niche in mercantile commerce, mercantilism and commerce, trade, retail, merchandising. A lot of them got their start, particularly in small towns, peddling goods, horse carts and on foot. And then when they could, would open shops or open stores. There were very few communities, very few towns anywhere in the United States that didn't have a Jewish-owned store as part of its main street. The picture that I've given you here of Bryan, Texas in about 1870, that of course is College Station, shows something I think it's maybe a little excessive in this particular example, but it shows the fact very clearly. I don't know if you can see the names on those stores. This is downtown Bryan. Kiefer and Kahn, Grossmeyer, Oscar, Sanger. These are Jewish names, Jewish immigrant families operating these stores. Not every main street was, 50% Jewish, but a lot of them were pretty prominently Jewish. This is where this particular group of immigrants made their impact. Starting in 1880, something very different began to happen. New wave, so-called third wave of Jewish immigration began between 1880 and 1924. 1924 is when Congress passed the Johnson-Reed Immigration Act that basically halted European immigration to the U.S. Between 1880 and 1924, about 2.5 million Jewish immigrants came. 2.5 million. That is about 10 times larger than the previous wave. This group is almost entirely Eastern European. That is, they're from the Russian Empire, what was then the Russian Empire. That is Russia, Poland, Lithuania, Ukraine, Belarus. Because they're coming from a different part of Europe than their predecessors, they're culturally very distinct. They're still Jewish, of course, but they're Jewish in a different way. Their primary language is Yiddish rather than German or French. They are generally more religiously observant, more traditionally religious. That is, they're Orthodox Jews rather than Reform. They tend to be a little more politically radical, maybe is not the word, but certainly a little more political. All of these, and significantly, the reasons they're coming have a lot more to do with escaping the conditions where they are. That sometimes maybe perhaps better to refer to them as refugees than immigrants. This is a significant number of people trying to escape deteriorating conditions in Russia. There was a great concern as they arrived among established Jewish leaders in the US that this was a very large group of people who were so conspicuously alien, so conspicuously different, that they might be unassimilable, that their presence could actually encourage Congress to take action to try to prevent their coming in. And again, with circumstances in Russia being what they were, it was very important to Jewish leaders here to keep that door open as widely as possible for as long as possible. Now, it didn't help their case that this group, by and large, did not disperse. They arrived in New York mostly, and they remained in New York mostly. About 75% of those 2.5 million who arrived remained in New York City, most in the same neighborhood, this neighborhood pictured here on the Lower East Side of Manhattan. The Lower East Side very rapidly became the largest Jewish population in the world, as well as the densest center of human habitation in the world. That is more people per square mile on the Lower East Side than anywhere else on Earth. And this, again, is of great concern to Jewish leaders who are certain that Congress will do something to alleviate the situation if they don't. These immigrants, partly because they're fleeing, many of them for their lives, they're poor. These are people who are in pretty desperate straits. And that's a circumstance that, again, the leadership is very concerned needs to be addressed. To try to alleviate the condition, Jewish leaders in New York formed an organization in 1901 called the IRO, or the Industrial Removal Organization. And as the name kind of suggests, the goal was removal, to try to identify immigrant Jews in New York who would be willing to move elsewhere. The IRO would foot the bill for getting them on a train, sending them to some other town, and there'd be an effort to find them a job that they were suitable to do. The idea, again, to not only diminish the Jewish population of New York, but to spread the Jewish population around the country as broadly as possible. For about 20 years, over about 20 years, the IRO removed approximately 75,000 people from New York and placed them in about 1,500 communities all across the United States. The concern that Congress would act if they didn't, or even if they did, maybe, was by no means made up. Congress was in a restrictionist mood. In 1905, the president, Theodore Roosevelt, in his annual address to Congress, recommended that they should find a way to separate what he called undesirable immigrants. That's Roosevelt's term. That we needed to continue to let in the desirable ones, but not the undesirable ones. He also said we needed to separate the right sort from the wrong sort. Again, his words. Roosevelt was kind of vague about what exactly that would mean, but Congress took action 2 years later in 1907 and identified those to be removed, or those to be debarred from entry, as being anyone, quote, likely to become a public charge. They want to prevent anyone from arriving so poor they can't sustain themselves. Also barred anyone who was mentally or physically defective, whatever exactly that might mean. Barred were contract laborers, anyone who was brought to the country or came to the country specifically to work in a particular job. And anyone whose ticket or passage is paid for by someone else. You have to come under your own steam. No one can sponsor you. No one can even really encourage you to come. In the face of a law like this, Jewish leaders are realizing, okay, the IRO is something, but perhaps it needs to be expanded. We need to take further action to prevent Congress from taking further action. In 1907, the movement began, orchestrated originally by Jacob Schiff, pictured here on the left, who was a financier, philanthropist in New York, a member of the Jewish immigration of the previous period, German, and very successful, very rich. And Schiff was a big supporter of the IRO, but understood that there was a kind of essential problem in how it was functioning. And that is that the goal of the IRO was to remove people from New York who had already arrived in New York. And once they were there, once they were in a neighborhood where Yiddish was spoken, where their religious facilities were available, where kosher food was readily available, they weren't very inclined to leave. And so Schiff's idea was, rather than try to remove people who are already settled, to divert immigrants before they arrived, put them on different ships for a different port, bring them in someplace else, and then send them to the best place for them to be. He worked with the IRO, that's David Bressler, also pictured here, was the manager of the IRO in New York, and is now going to be the manager of the Galveston movement. They settled on Galveston as the proper port of entry for a number of reasons. First of all, it was as far away from New York as you could go without switching oceans, right? The goal is to get them away from New York. Galveston was the furthest west Atlantic port. It had an immigration and customs station already in place, so you could come into the country properly there. It had rail connections linking it with much of the rest of the country. And as I'm sure many of you know, there had been a hurricane in Galveston just a few years before in 1900, and the city was virtually destroyed. It was rebuilding, it was improving, but it wasn't an especially pleasant place to be in 1907. And for Schiff, this was an important concern. The goal was to get people to move through a port and out to somewhere else. He didn't want to send them someplace they'd be inclined to stay. They considered New Orleans as a port of entry and said, you know, nobody would ever leave New Orleans. Why leave? So Galveston was sort of viewed as a better alternative. And then finally, Galveston was the home of Rabbi Henry Cohen. Cohen was revered. He had been in Galveston for about 20 years at this point. He was recognized as a progressive leader. He was a great humanitarian. He was a spokesman, not only for the Jewish community, but often for Christians in Galveston as well, and was about as highly regarded as an individual can be. Cohen was willing to lend his effort to this project, in particular to be essentially the person who greets the recipients at the door. When they arrive at the port of Galveston, Cohen would be there to meet them. He spoke Yiddish. He was, of course, familiar with facilities in the city. He was very good at helping the immigrants kind of find their way through the process, get on board the correct trains that were going to take them to their eventual destinations. Many of the immigrants who passed through Galveston years later remembered Cohen as basically the one bright spot in an otherwise pretty arduous voyage. And so having Cohen on the ground there in Galveston was a major inducement to choosing Galveston. Process as this operated was to select the immigrants in Russia to identify who was a likely immigrant to the U.S. Of course, they couldn't encourage anyone to be an immigrant to the U.S., but they could try to identify the ones who were coming anyway. They could encourage them to come to Galveston, tell them that if they did, they would receive support once they'd arrived. They couldn't be very specific about what that would be, but they would help them. And to encourage them to then take the ships that arrived in Galveston rather than New York. Once arrived, they'd be interviewed, their skills and their trades identified, they'd be matched with available jobs throughout the United States, and then put on trains at bureau expense. The immigrants, once they were in the country, you could pay their way. So the bureau paid for them to travel to their destinations. During the 7 years that the Galveston movement operated, about 10,000 Russian Jews were brought through Galveston, distributed to 236 cities in 32 states. As this map kind of indicates or suggests, Texas got more than anybody else, about a quarter of the total. This by no means is restricted to Texas. This was truly a national effort. About 12 cities got the bulk of the immigrants. Kansas City was the largest single recipient. That was mostly because of one indefatigable social worker who insisted on receiving more than anybody else. But St. Paul, Omaha, Houston, Dallas, Minneapolis were all big recipients. Several of these cities initiated like training programs and schools and language classes to try to facilitate the assimilation of the immigrants once they had arrived. In spite of all of this, Schiff chose to terminate the program after only 7 years. There were a lot of reasons that it was disappointing. The results were simply not what he had hoped. A lot of it had to do with the simple fact that getting to Galveston took 2 weeks longer than getting to New York. And it was difficult to sell immigrants on the idea that they should travel 2 weeks longer. But the real issues, the deeper problems, were legal. The organizers of the movement did everything they could to remain within the law. They tried very hard not to make specific promises about jobs that would be received once they'd arrived, because that would look like contract labor. They tried very hard to make sure that no one paid passage for the immigrants. But their European partners, those in Russia and Germany, who were sort of doing the selecting and the recruiting on that side of the ocean, they were much less particular about the nuances of U.S. law. And they frequently made specific promises that violated U.S. law. So Schiff was very frequently just trying to explain or justify the movement to legislators and authorities. And this at some point got too burdensome. In addition, there were severe problems with unequal interpretation of the law. What, after all, is mentally or physically defective? Who decides what that means? Who decides who is likely to become a public charge, likely based on what standard? In practice, those decisions were reserved for immigration officials, customs officials at each port of entry. They each made their own determinations, and they varied widely. As it happens, Galveston was among the strictest ports of entry anywhere in the United States, just simply because of the personnel stationed there. Of the Jewish immigrants who arrived in Galveston, 4% were barred from entry. When they were barred, they were put back on the same ship and sent right back to Bremen, Germany. 4%. That's compared to 1% in New York. In fact, a lot of the people who were debarred from Galveston went back to Bremen, got on the next ship for New York, and got in with no trouble. So as word of that fact spreads, that reality, obviously it gets harder to sell people on this option. One of the reasons given for why conditions were stricter in Galveston, and this is somewhat speculative, but Henry Cohen said as much, and he would know, is that the medical inspector at Galveston was anti-Semitic, that it was a simple choice that he made to let in as few people as possible, or rather to exclude as many as possible. Under conditions like that, Schiff realized that there really was no way to continue. In April of 1914, he terminated the program. The timing is significant. World War I started just a few months later. Schiff, of course, didn't know that was coming and had nothing to do with his decision. But the fact is, World War I would have ended the program anyway. So what does all of this tell us about present day? How is this in any way a useful piece of history to know? I think one way to consider the Galveston movement is that it provides thousands of case studies of immigration done right. Thousands of stories of people and families who entered the United States successfully, who demonstrated that the various terrible things that supposedly immigrants were going to do never materialized. The allegations that were frequently made of immigrants at the time, and you'll recognize these will sound familiar, they're going to bring poverty, they're going to bring disease, they're going to bring crime. And what the Galveston movement demonstrates is that none of those happened. This was a circumstance where, through a kind of organized effort, immigrants were pre-selected and brought in who were going to be acceptable under American law. The family I've showed you here, Alexander Gurwitz, seated in the middle, came through Galveston in 1910, settled in San Antonio, Texas, where he lived out the rest of his life. When he immigrated, he brought four children with him, four plus his wife. Three of those children now as adults are in this picture taken in South Texas, in Alice, Texas. Every adult in this picture was an immigrant, four of them through Galveston. All of the children in this picture were born in Texas. And I think this is a picture of sort of what one would expect would happen or would hope would happen. The Galveston movement offers a lot of examples of this process going well. It's also important to recognize it as a case of immigration law being selectively enforced or unequally enforced. The immigrants coming in through Galveston were pretty much a best case scenario. They are well supported by a community already here. They've got Jacob Schiff's money behind them. They are willing to work, ready to work. They come for the purpose of contributing to American society. And yet, one or two individual officers at one port of entry were empowered to basically keep them out as a matter simply of their own bigotry. The inequality, one maybe would say the lack of due process, caused a program to be terminated that was pretty beneficial and doing pretty good things. And then finally, I'd add this as something that perhaps a study of Jewish immigration makes especially clear. But when we're looking at Jewish immigration to the US, it's a very stark example of the simple fact that immigration saves lives, that the immigrants themselves are spared because they're here. Everyone pictured in this photograph, the Gurwitz family of San Antonio, everyone pictured here in 1937 was not in Europe in 1937. Everyone who came through Galveston and was able to find a home in the United States was spared what was coming later. Now, of course, Jacob Schiff didn't know that. None of them knew that. But the reality remains, this was a rescue program for a crisis they didn't even know was coming. And I think that's an important thing for us to keep in mind as we consider our own policies and our own approach. Of course, we're going to be primarily concerned with the effect immigration will have on America, on American society, but the benefit to the immigrants themselves too is extreme. And I think that's not irrelevant. That is an important point to keep in mind. So the Galveston movement is a unique case. It's one of a kind. I'm not aware of any other like it with any other cultural group. It's a specific moment in time. And yet its goals and its outcomes have a great deal of resonance for our own circumstances and for immigration law and enforcement today. So thank you very much.
Thank you, Professor Stone. That was fascinating. I'd now like to introduce our next speaker, my colleague, Professor Daniel Morales. Professor Morales is the Dwight Olds Chair and Professor of Law at University of Houston Law Center. He's a scholar and theorist on immigration law, known for his work challenging the illegality of immigration controls and highlighting the advantages of a less nationalized immigration system. His scholarship has appeared in leading law reviews, including NYU Law Review, UC Irvine Law Review, Indiana Law Review, and Wake Forest Law Review. He's the co-editor with Professor Nick DeGenova of a forthcoming book of Duke University Press explaining the applicability of abolitionist thought to the immigration context. He's a frequent commentator and contributor on local media. He has appeared in the New York Times, The Guardian, among others, NPR. He began his academic career as a William Hastie Fellow at the University of Wisconsin. He clerked for the Circuit Court Judge Guy Cole, the Sixth Circuit, and District Court Judge Joan Goshal of the District Court of Northern Illinois. He has a JD from Yale. Let's welcome Professor Daniel Morales. Thank you, Daniel.
All right. Well, thank you so much for allowing me to be here, Dean. I hope you're as excited about this panel as I am. I am just a big fan of immigration history. And I think you're really getting a treat today. You're hearing a lot of information I don't think is commonly known. So I'm not a historian. I'm just a fanboy. So it's nice to be on a panel today that has some of the most important scholars of immigration history in the U.S. And so as a law professor interloper, I'm going to keep my remarks brief. And I think my remit today, at least as I'm going to define it, is not going to be so much to teach you history, though I will do some of that. Instead, I want us to reflect a little bit more broadly about what serious engagement with what really happened in the past, right, that is history, gives to people engaged in the present moment who are attempting to create the conditions for a better future, particularly through the law, right? If that sounds a bit heady, I think more concretely what I'm going to do today is give you some examples of what engagement with academic histories can do for legal scholarship, or at least has done for my scholarship and thinking about immigration law. I'll start with an example of the uses of history that is more narrowly legal, and then open up to describe how engagement with academic historians can, I think, catalyze legal creativity and expand the universe of possible legal change that we might consider. So to start, right, the original intent of laws is something we hear a lot about these days, and it's an important thing to know in today's legal environment, owing in particular to the current makeup of the Supreme Court, which tends to care a lot, at least on paper, about what the original intent of laws is. And so engagement with academic history can, I think, help us immensely with this project of understanding intent. Even if, as the record, I think, shows, such analysis of intent usually doesn't fully resolve the problem of judges having to make a choice between competing interpretations available to them. So one very clear and interesting example of the importance of academic history when it comes to original intent that I want to share with you today recently actually played out in litigation relating to what are called immigration crimes. And these are the crimes of illegal entry, 1325, and illegal reentry, 1326. And these criminalize, respectively, crossing a U.S. land border without permission, only if you're a non-citizen. And the second one, 1326, makes it a felony to do the same thing after you've been previously deported. So these crimes are actually kind of strange for a bunch of reasons that I'm not going to go into, sort of unrelated to history. And in fact, they're weird enough that I wrote a whole law review article. I published about a decade about them. And I argued in that article from criminal law theory perspective, right, that these crimes shouldn't be crimes at all. But another set of much smarter law professors than me decided to do one better than write a law review article. And they actually made an effort to challenge illegal entry and reentry statutes as violative of equal protection under the 14th Amendment, because the original intent of these laws was, in fact, blatantly racist. And so I'm going to read extensively now from one of the historian's briefs discussing the racist intent behind the statutes. And I'm going to talk about those. And in the course of this, you'll also be learning a little bit about one tranche of Latino immigration to the United States, particularly that is related to Mexican nationals. Okay, so this brief was filed by Kelly Little Hernandez, May Nye, and Ingrid Ely. These are all eminent legal historians, or eminent historians and law professors in the United States. Okay, so quote, and this will be a long one, so just bear with me. So the felony unauthorized reentry after deportation statute, like its misdemeanor counterpart, traces its origins to the 1920s, which I think you're starting to hear a lot about, or you've already heard a lot about from the other professors. That era saw increasingly vocal and active white resentment of other racial groups, a period so racially fractious that it earned the moniker the Tribal Twenties. This was, quote, a time when the Ku Klux Klan was reborn, Jim Crow came of age, and public intellectuals preached the science of eugenics. While these restrictions on immigration from outside Europe were remarkably stringent, nativists had actually been pushing for even greater restrictions on non-European immigration. However, they were stymied by business opposition from representatives in Western states, which increasingly relied on the Mexican immigrant workforce. And this was, in fact, due to other forms of restrictionism, the decline of white male itinerancy, the exclusion of Chinese workers, and the nadir of California's indigenous population. Mexican immigrants had emerged then as a significant portion of the low-wage workforce in the region. As the president of the Los Angeles Chamber of Commerce put it, quote, "We are totally dependent on Mexico for agriculture and industrial common or casual labor. It is our only source of supply," end quote. Speaking on behalf of himself and various Livestock Raisers Association, rancher Freddie Bixby from California testified before the Senate about industrial reliance on Mexican labor. He noted that in California, and there are some slurs in here, but I think I'm going to use them because I think it's important for you to understand the history here and how blatant it was, and they are in the brief. Quote, "We have no Chinaman, we have not the Japs, the Hindu is worthless, the Filipino is nothing, and the white man will not do the work," end quote. At the time, immigration authorities counted approximately 100,000 Mexicans crossing the border each year. The nativist proposed quota would have limited entries to a few hundred. So agribusiness at the time, right, was opposing any quota system simply because they relied on Mexican labor. Because the bloc of pro-business representatives opposed the quota, nativists were forced to choose between a Mexican exemption to the quota system, this is in 1924 when we placed quotas on Europe, and no immigration quotas at all. And so they chose the former. The law ultimately exempted from the quota system imposed on Europe all immigrants from the Western Hemisphere, whereas all other nations had a combined annual limit, all other nations all over the world, of 165,000 immigrants. So the nativists didn't like this compromise. Congressman John C. Box, who would later co-sponsor a 1926 bill that would have limited Mexican immigration, opined, quote, "The continuance of a desirable character of citizenship will be violated by increasing the Mexican population of the country," end quote. "What is the use of closing the front door to keep out," another quote, "keep out undesirables from Europe when you permit Mexicans to come in here by the back door and by the thousands and the thousands," end quote. So with the Western Hemisphere not subject to the quota system, Mexicans continued to immigrate in greater numbers. By the end of the 1920s, Mexico became one of the leading sources of immigration to the US, but the nativist backlash continued to build, leading to the Undesirables Act of 1929. And this is where we get the immigration crimes from, right? And so the compromise was in 1926, an agribusiness novelist, a lobbyist named S. Parker Frissell testified, "We gentlemen are just as anxious as you are not to build the civilization of California or any other Western district upon a Mexican foundation." With the Mexicans comes a social problem. It is a serious one. It comes into our schools, it comes into our cities, and it comes into our whole civilization in California. Another interesting set of arguments, and end quote, was an argument about Puerto Ricans. And the argument was that in the absence of Puerto Rican, in the absence of Mexican labor serving in the West, then Puerto Ricans would come, and Puerto Ricans were viewed as Black at the time, or Black Puerto Ricans were feared to come. And so again, as Professor Kenny and others have sort of pointed out, there's this intersection between immigration regulation and other forms of regulation of racial movement. And so there was some real concern that in the absence of Mexicans, you would get Black Puerto Ricans instead, and that was viewed as undesirable. And so I ended the excerpt a few paragraphs ago. But as you can see, right, this history is a really powerful example of what historians can give us, and this was all original archival research that these historians had done in their research, published in various books by the historians who wrote the brief. So that's one use of history. You may be wondering how the litigation turned out. Ultimately, the Ninth Circuit rejected the equal protection claim, finding in essence that the repromulgation of the law in 1952 as part of the Immigration and Nationality Act expunged the obvious racist intent of the initial law. Historians contested the finding in amicus briefs too, but they did not manage to persuade the circuit court, largely because the racism in 1952 was far more subtle in the view of the court. All right, so that's, I think, the use of history in law that we're most familiar with. Other uses of history, though, and I hope you're feeling some of these in listening to these talks, right? And I think these are different in that they're less about defining or fixing the meaning of things and more about opening them up, right? I think as human beings, we tend to be biased towards the present. The current shape of things is what we inhabit, experience, and what we know. And we know it in the most three-dimensional sense because it's what we live, right? And I think as attorneys, we often suffer a more acute version of presentism. And that's because one of the functions of law is to protect, defend, and preserve the status quo, right? That's one of the things it does. And so the way society is presently organized, for all its blessings and its flaws, can be hard for lawyers and law professors to imagine other ways of ordering things or even grasping the idea that the world could be another way. I think, at least for me in my work, that reading good history, like the work produced by the stars we've assembled from this panel, is an antidote to that status quo bias, right? Good histories help us see both the contingency of the past, the way human beings just like us made the past and shaped the present, and the structures of the past that were less movable, more determined, more fixed in place. These kinds of insights, I think, allow someone like me, who's not a historian, but who wants to write work to help make a better future, enlist a kind of what I'm calling informed and strategic sense of the plasticity of the present or the future, right? And so in this vein right, the history of how the US came to have a highly nationalized and centralized form of control over immigration, what Professor Kenny told us so thoughtfully and carefully, reading that history got me thinking about whether such fully centralized control was the best form of organization of immigration control in this historical moment. So even though national control has been breeding progressively more unjust and self-destructive outcomes, in my view, under both Democratic and Republican presidents and Congresses for over 4 decades, I think an idea persists in the literature that we are just simply better off from an immigrants' rights perspective with the extreme centralization that history has bequeathed us in immigration law, and that we seem to continue to double down on. But then I started reading histories about how immigration was regulated before the Chinese Exclusion Act, where localities, in particular localities like Boston and New York City, for example, played a much more important role in immigration regulation. And I wondered if that sort of system could help us today. And so that bare fact, for me anyway, of the prior existence of more local control in the past ended up helping me unshackle myself from my status quo bias and help me draft a series of articles exploring the possibilities of a more decentralized immigration system that is compatible with the present. I should say, too, that this example from the history is not literal at all in the way that perhaps the originalist example was, right? And as Professor Kenny mentioned, that the historical examples are not obviously promising for someone who likes me, who thinks that immigration is a good thing. When they had control of immigration, New York City and Boston engaged in rampant abuse of their immigration powers. They deported people to places they had never set foot in. They rampantly stereotyped immigrants, particularly Irish immigrants, as lazy and worthless, more loyal to the Pope than the Constitution. And so these localities were generally as reactive and punitive as the national government today. Yet just knowing this history in combination with what I view as the very bad state of things in the present got me thinking about how conditions and possibilities for decentralization might be different today because the world we inhabit is different than the world we inhabited when these laws were the law of the land, right? And so one of the possibilities that history inspired me to think about was this notion that perhaps we could grant the city of Chicago power to prevent a deportation of a local non-citizen resident with a single DUI. We could just delegate that from the federal government to a locality. Or vice versa, give a rural town in Iowa the ability to issue visas where a national corporation wants to build a meatpacking plant and condition those visas, say, on that corporation paying for a new public school in town that will educate the children of these non-citizen workers. Now, notice this is never how things have worked in the US historically, but reading in detail how things had worked differently really unlocked my personal creative capacity to reimagine a system that appears to serve no one particularly well. And ultimately, the kind of massive changes I have written about to the way that we can do immigration law are going to be subject to a lot of disagreement, right? But perhaps the unsettling that I do in my work, inspired by the unsettling I felt in reading history, will lead to some positive changes in the years to come. The last thing history can do for non-historical forms of legal scholarship is to remind us that the world has continuities, but it's always changing and changeable. The present 40 years of radical increase in immigration enforcement across all presidential administrations, for example, is without precedent. What does that tell us? Well, there are powerful interests that wish to perpetuate this status quo, for one, but it also tells us that the world has been different before and it will be different in the future. This trend may go on for our lifetimes, but it will not go on forever, I think, because nothing in history goes on forever. And there's a particular kind of hope and perspective in the historical arc that we need now, or at least that I need now, to keep doing the work I do, fighting for the truth as I see it and the facts at hand. Thank you very much.
Thank you, Professor Morales. That was great. And I have the treat to participate as a panelist in the CLE today. So I'm going to be talking about Black migration to the United States. Let's see if I can find my slides. Hold on for 1 second. One second. Here we go. Well, let's share. Great. Can you all see that?
Yes, we can see it, Dean.
Great. Thank you. Let me go from the beginning. So we're going over this slide. So my first point is, what do these 12 individuals have in common? Marcus Garvey, some may be more familiar to you, obviously, the more contemporary folks, Vice President Harris, President Obama, President Omar, General Powell, Shirley Chisholm. What do they all have in common? Well, they all are either immigrants to the United States or children of immigrants to the United States. And what's so interesting about this is, and these are places of origin that they are from. You know, Marcus Garvey was a civil rights leader. He wanted to go take Africans back to Africa. Stokely Carmichael was a civil rights activist, leader. He's from Trinidad. Audre Lorde is a scholar, writer, theorist. She's from Barbados and Grenada. Malcolm X, his mother's family is from Grenada. Sidney Poitier was the first black man to win an Oscar, Best Oscar. He was from Bahamas. Harry Belafonte was a known Calypsonian, was from Jamaica. Shirley Chisholm was the first black woman congresswoman. She was considered herself Barbadian, but her father's family is from Guyana. Colin Powell was the first black Secretary of State and first black chairman of Joint Chief of Staff. And he was family was from Jamaica. Lonnie Guinier, that's a photo from Yale, but she was the first black woman law professor at Harvard Law School. Her family was Panamanian, but through Jamaica. A lot of people in the Caribbean, British Caribbean, went to Panama to work on a canal, and that's where they ended up. Ilhan Omar is from Somalia, was a refugee from Somalia. Barack Obama, his father was from Kenya. And Kamala Harris, her father was from Jamaica. So as I said, all of them, they were born outside the U.S., or their parents immigrated to U.S. And for many of them, it's really before the Brown versus Board of Education and the Civil Rights Acts of 1960s. So it's really remarkable. And I'm not an immigration scholar. I'm not an immigration anything with respect to this, but I do like history. And part of it is like, it's very interesting to know, because my family, as many of you know, is from the Caribbean. And so it's just so fascinating when I study and learn about the history of these people, that what I saw as commonplace was part of this larger movement of people coming to the United States, especially from the British Caribbean, like my family, over 100 years ago. My grandmother, but was on my mother's side, was the first one to come to the United States, and she came through Ellis Island more than 100 years ago. So as was spoken before by many other panelists, there was involuntary migration of people of African descent origin between during the pre-Reconstruction amendments, and also the Constitution actually has a provision barring slave trade after 1808. But there was always migration between people of African descent, even during this period of time, because a lot of the slave owners, the land barons, often owned property or involved in commerce between the Caribbean and the United States. So you find it certainly with Haiti and what was New France, or before the Louisiana Purchase, Louisiana. There was often trade of people and movement of people between Louisiana and Haiti before Haiti became an independent republic, as well as the Carolinas, North and South Carolina, and Barbados. There was a lot of migration of Black people and people generally between that during the time of the 13 colonies. But then you had voluntary migration, which is basically early 1900s to the present, voluntary Black migration, early 1900s to the present, like my family. So as I mentioned, the transatlantic slave trade marked the beginning of the migration of Black population to the U.S. In 1619, that was the first record of enslaved Black Africans in the U.S. Legal importation of enslaved Africans ended in 1808. The legal importation, there were illegal importation of enslaved Africans even after 1808. And the Black population in the United States was almost 19% of the population in 1810. That was mentioned by several other commentators before. The earlier Naturalization Act restricted naturalization of free white persons. In 1870, the Naturalization Act included people of African nativity and persons of African descent. But the question is, who are people of African nativity and persons of African descent? Because does that mean that you are actually directly from Africa? Or what about the people from the Caribbean? So there was about 140,000 Black immigrants from the Caribbean between 1899 and 1937. Most were British from the British Caribbean, migrated to New York City, like my family, through Ellis Island. The migration peaked in 1924 to about 12,250 per year and declined thereafter, especially during the Great Depression. And the foreign Black population increased from 20,000 in 1900 to almost 100,000 in 1930. And as I mentioned, over 140,000 Black immigrants passed through U.S. ports between 1899 and 1937. Why did they come? They came for the same reasons that people from other parts of the world came. There were natural disasters, hurricanes, floods, earthquakes, volcanoes that caused devastation and they needed to leave. There was economic downturn due to increased competition with sugar. Sugar was the big industry in Jamaica and Barbados. There was more beet sugar from Europe and more cane sugar from Brazil that was competing. There were very difficult work conditions in the Caribbean, and especially as economic downturn affected those who were working. There were more economic opportunities in the United States. And the other thing which struck me as I was doing this research is that because the British Caribbean was such an important part of the British Empire, it was a lot of transportation, really cheap transportation in terms of steamships, of extensive shipping network from Barbados, Trinidad, and Jamaica to the United States. But that didn't mean, as other commentators said, that people were happy about having these more Black people and Black migrants from other parts of the world in the United States. So Senator James Reed of Missouri, during debate, sought to amend the Naturalization Act of 1917 to exclude Black or African race from migrating to U.S., but did not pass. And what was so fascinating as I think about this era is and you think about the 12 people that I cited, is how they became such an integral part of the Black American community. And you see the opposition by the African American press to Senator Reed's proposal, by the NAACP, and between the opposition by Booker T. Washington and W. Du Bois, who were often in oppositions of each other. And the other thing is, one thing to keep in mind, Du Bois is a French name, and he actually has his ancestry in Haiti. So the Immigration Act of 1924 established quotas, 2% of foreign-born for each nationality, enumerated in the 1890 census. For the people from the Caribbean, this caused migration to plummet, but the people from the British Caribbean were also allowed in under the United Kingdom's quota, which was 34,000, and they often did not use the full amount of their quota. So a lot of people came in as a result of that. And also keep in mind, they were British subjects at that time. And so any sort of bad conduct would be against some of them might be a problem for the United States and the UK to some degree. But the quotas were calculated on the 1890 census, and the law specifically excluded descendants of slave immigrants, meaning those who are here and were of African American origin, when determining these quotas. This decision again had this effect on excluding Black immigrants from the rest of the world and limited it, even though those from the British Caribbean were able to get in under the British quotas. But the challenge, of course, was what did African or African descent or African nativity mean? There was a procedure for recording race on naturalization records. It was revised so that the applicant actually then chose his or her race, or citizenship, and it was basically still white, African, or African descent. But they then changed it in terms of the list of races that people could qualify or be eligible for to Black. African Black was changed to Negro, which was a common U.S. usage for people of African descent before. And this then allowed people from the Caribbean, because the question is like what it was open question is that if you're from the Caribbean, yes, you may be of African nativity, but you're not coming straight from Africa to the United States. And so it opened up more doors by having a little bit more commonplace notion of how Black people are defined in the United States as opposed to just African or African nativity. And then there was basically almost like a drop-down menu that was designed. It wasn't a drop-down menu then, where it designed this form that allowed for choices of 5 different categories, which was white, Negro use of the time, Japanese, Chinese, or other. So the 1965 Act, as many have also mentioned on this webinar, made an incredible difference in migration to the United States for people of everywhere, including those from the Caribbean. It opened up many, many doors, and you had basically an explosion of people from the Caribbean and also from Africa migrating to the United States. So there's this, people of African descent, there's this growing number of Black immigrants from Africa, but Black immigration from the Caribbean is still the largest place of origin of Black immigrants to the United States. So there's a changing nature of who the people of African descent who are immigrants to the United States. And we see that people who are African or Black or Caribbean immigrants are becoming a larger and larger part of the Black population in the United States. When I think of the time of my ancestors who came here, it was only 140,000 people, but now there's millions of Black people from other places in the United States. And you can see the Black immigrant population as a Pew Research Center charts that shows that the Black immigrant population, foreign-born population, is expected to climb, and it's now about almost to 4.6 million, is projected to reach 9.5 million. If in fact the immigration policies are as they're changing, don't necessarily affect them in the future, but it's been growing at a rapid pace. And the percent that people of Black immigrants are now of the Black population in the United States is now almost 10%. Now, in New York, where I'm from, the Black immigrant population was always very large percent of the Black population in New York. For decades, it's been maybe 25%. The foreign-born Black immigrant population was 25%. But now nationwide, the Black immigrant population is 10%, which is significant. And what's even more significant, if you look at not just the Black immigrants, those are foreign-born, but of their children. So again, the 1 in 10 Black people in the United States are immigrants. It's up from 3% in 1980, so nationwide. But if you look at the first and second generation, it's about 20% of the people in the United States, Black people in the United States, are either foreign-born or children of those who are foreign-born, which is significant change, and it's basically been fairly nationwide. Now, the largest number of immigrants still are people from the Caribbean. The Black immigrants are people from the Caribbean, but you can see the difference if you look from 2000. There were almost 3 times more people from the Caribbean than from Africa, and now it's almost evenly divided between the Caribbean and Africa, the number of Black immigrants in the United States, foreign-born people in the United States. So migration from Africa has fueled the bulk of growth in the Black foreign-born population. As I mentioned, from 2000 onward, in 2000, roughly 560,000 African-born Black immigrants lived in the United States. By 2019, that number had more than tripled to 1.9 million. And many of these immigrants are newer arrivals to America. 43% of African-born immigrants immigrated to the U.S. from 2010 to 2019. So 43% who were African-born Black immigrants. So almost half of the African population, African-born population, came fairly recently to the United States. Jamaica and Haiti are still the primary place of origin of Black immigrants. And I think Haiti's been increasing over time. Jamaica is still fairly large, but you can see Jamaica is about, in 2019, 760,000. Haiti's increased, as I mentioned, significantly from almost not quite doubled, from 410,000 to 700,000. And then the African countries, Nigeria, Ethiopia, Ghana, have increased significantly between 2000 to 2019. Among Black immigrants in 2019, those who were born in the African country, in an African country, are the least likely to have lived in the U.S. for more than 2 decades. So if you look at this polling data from Pew Research Center, you see those who've lived in the U.S. who were born in Africa, only 25% have been here 20 years or more. But you look at the Caribbean, it's 56% have been here 20 years or more. Central America or Mexico, 59%, and South America, 54%. Live in a household headed by a married couple for U.S. Black migrant immigrants is 54% overall, but for Africans, it's the highest of the groups of Caribbean, Central American, and South America. But have obtained citizenship. You see Caribbean and South American Black people have the largest percentage of those who've obtained citizenship, probably due to the fact they've been in the United States for so long and may have relatives like my family that have been in the United States for decades. In terms of where they live, most Black immigrants live in the Northeast and South. And so, again, New York has always been a hub, especially New York City. You can see the most number of Black immigrants are 1.1 million in New York, Jersey City area. Florida, South Florida, Miami Beach, West Palm Beach is also a significant number where people are. It says 42% are in the South, but most of the people in the South are in Miami, Fort Lauderdale, West Palm Beach. Washington, D.C. is also a big area. And in terms of significance of where the Black population is, but you can see they're everywhere in terms of most Black immigrants live in the Northeast and South, but they're a significant portion of the Black population all over the country. In terms of the top states for residents for U.S. Black immigrants, as I mentioned, New York State, significant. Florida is now almost tied with New York. It used to be 400,000. Now it's 800,000, so a growing portion of the Black population, Black immigrant population in Florida. New Jersey, California, and Texas also grown, doubled between 2000 to 2019 from 100,000 to 200,000. Georgia doubled from 100,000 to 200,000. So significant increases in a lot of different places. California also has tripled from 100,000 to 300,000. In the Texas, the Dallas-Fort Worth area and Houston Sugar Land metropolitan area have seen a 200% growth in Black immigrant population since 2000. In terms of educational attainment of Black immigrants versus immigrants generally and Black Americans, you see for U.S. immigrants of all backgrounds, it's like 33% have attained a certain degree of education, a bachelor's degree or higher. Black immigrants, 31%. Those from Africa, 41%. South America, 27%. Caribbean, 23%. Central America or Mexico, 15%. And then in terms of different African countries, very highly educated. Nigeria, 64%. Cameroon, 53%. Kenya, 47%. Ghana, 41%, et cetera, et cetera. You can see the rest. First Caribbean country on the list in terms of percentages is Trinidad and Tobago at 28%, Jamaica at 25%. In terms of Black immigrants who live below the poverty line, you can see from this chart from the Pew Research Center that in terms of U.S. population, 11% of people live below the poverty line. For U.S. immigrants, it's 13%. For U.S.-born Black population is 19%. For U.S. Black immigrants, it's only 14%. So it's less than the U.S.-born Black population. It is higher than the U.S. immigrant population generally, and higher than the U.S. population overall. And if you look at the different places where they're from, you can see in terms of those who live below the poverty line that Africa is 16%, the Caribbean 11%, Central America, Mexico 16%, and South America 12%. Black immigrants are less likely than U.S. population or overall immigrant population to be homeowners. So U.S. population 64% are homeowners, U.S. immigrants 53% are homeowners, U.S. born Black population is 42%, U.S. Black immigrants 42%. But then when you break out the immigrants, Black immigrants by place of origin, you see those from the Caribbean at 49%, still lower than the U.S. population overall, lower than the U.S. immigrant population overall, but 49% for Caribbean, people from the Caribbean, 44% for those from Central America, Blacks from Central America, Mexico, 48% for those from South America, and 33% for those from Africa. And again, a lot of this may be the more recent arrivals to the United States for people from Africa. And what's fueling increase in immigration from Africa, because it's really growing significantly. I think of our law school population of the students, and there's a lot, more people of African origin or descendants of people from Africa, directly from Africa as part of our population. It's a great thing, but why is it happening? Why is it increasing? Well, again, it's the removal of the country quotas that we had before the 1960s. The immigration laws emphasize family reunification and skilled immigrants. The Refugee Act created a system of asylum and admissions for those who are in emergent situations. And the Immigration Act of 1990 created this diversity immigrant visa to encourage immigration from countries that did not send many people to the US. So what does this mean for the United States, and specifically for the African American population in the United States? By African American, I'm saying meaning all Black people in the United States. So what it means, I think, is increased internationalization of the African American population in the United States, because now you have 10% who are foreign born and about 20% who are foreign born or children of those who are foreign born. So that's a significant percentage. And if you look at localized in certain areas, it's like New York is huge in terms of percent of Black people who are foreign born or children of foreign born, or South Florida. This increased heterogeneity among and between U.S. Black immigrants and the native Black population means that there'll be differences in religion, language, history, and culture. So many similarities, obviously, but many, many differences, especially between those who might be from the Caribbean, which was UK colonies. Many of the English is the first language, many times Christian, have very Anglo names, versus others who may from Africa, some place in Africa where there may be a lot more diversity in terms of religion. The names might be a little bit more different. The cultures may be a little bit different, but not distinct. I also think there's under recognition of the broad immigrant background of U.S. Black population. So people forget that there's such a significant percentage of Black people in the United States who are immigrants or children of great immigrants that may have an effect on the services and of that immigrant population. And the last thing I would say is that as the Black immigrant population grows in size, we've observed really more othering, in my personal opinion, and not as dean. We see more othering of Black immigrants than we may have seen in the past. And when you see those photos they have of 12 famous people, with so many of them seemingly seamlessly entering Black society, and many of them becoming Black leaders and winning recognition and awards, and Black Americans, Black people in the Caribbean voting for them for office, winning Oscars, all sorts of things, and the overall population doesn't seem to notice or care. But as the amount grows, one of the stereotypes that African Americans didn't have in the more modern era is the stereotype of being a foreigner. Yes, back in the day, as some of our previous panelists have spoken about, there was this question, like after slavery ends, what do we do with the Black population, right? Back then, it was like, what do we do with it? And that's why there was this movement of attempting to send Black Americans, those who were formerly enslaved, to Liberia and Africa, but there were also other places they wanted to send them. They wanted to send them to Haiti, they wanted to send them to Dominican Republic, they wanted to send them to Panama, among other places. There was that. So what do we do with them to make sure that they were able to fit in the United States? And then I guess after the Civil War amendments and the struggle for equal rights and civil rights, that became less of a stereotype for people of African descent. Of no one was going to necessarily say to you, they may say other things to you, but they're not going to say to you, go back to your home country, go back to Africa. That's not something they would necessarily say to you, because that was something that we were all part of the same community. People knew we're part of the same community. But you see more of this now, I think, than we've seen before. And you think about this with the birther movement with Barack Obama. And again, he's an example. His family's from Kenya. He has, as he said, he's the skinny guy with a unusual name. One wonders if Colin Powell was the first Black president, whether he would have gotten the same sort of treatment from Jamaica with a name like Colin Powell. I don't know. It's hard to know. But you see that. You see with like a few years ago, the members of the squad were told to go back to their home country, and one of the women on the squad is African American represented from Massachusetts. We've seen that during last election that people of Haitian ancestry were said to be eating people's pets in Ohio or wherever it was. And so it's just sort of interesting that there's lots of things people may say in terms of stereotypes about people of African descent, people of Black people. But in terms of this sort of foreignization, this otherization on that scale, that is something that's a little bit newer. And I think that for me would be the big takeaways, because I think as the population has gotten larger of people of African ancestry, and also more diversified in terms of people coming from a lot of different places with what may be perceived to be a little less Western tradition. As a result, that I think is what's causing or we're finding this sort of new realm of seeing some people of African descent as foreign. And that's all I have to share. And so I invite the other panelists to come back. So we have about 20-ish, 25 minutes for a roundtable conversation. And people at home, please feel free to give us some questions in the Q&A. So is everybody back? Let's see. Yes, no, wait, are we saying, there you go, everybody's back now, great. So first question, in your collective research on past immigration histories, what strikes you as the most similar and or most distinct from what is happening now and today with what has happened in the past? So what strikes you as most similar, and what strikes you as most distinct between yesterday, however many yesterdays ago, and today? Any thoughts? Professor Morales, looks like you want
No. That was no. That's a hard question.
I can say.
Oh, go ahead.
I'm sorry, go ahead.
No, go ahead.
It's something that I never would have thought I would ever be able to say or would need to say. But even with, at least in the period that I was discussing, where there was restriction against immigration, there was at least a presumption in Congress that the goal was encouraging immigration, at least of a certain type. And what has, to me, is so just sort of shocking and devastating about the current situation is that seems to have reversed. And the principle seems to be keep everybody out, except maybe a very small number of select people. And that's, to me, not only self-destructive as a society, but that's kind of a violation of what the history points us to, and something I can't explain. I mean, it makes no sense. But it's certainly something that I think is different from what I've seen in the past.
Wouldn't you say, Professor Stone, though, that there's been a sort of back and forth of encouragement of immigration and then backlash?
Periods that are more welcoming and periods that are less.
Yeah.
Yeah, but was there a time ever where the goal seemed to be zero immigration? I don't know that I can think of one. And I don't know that we're in one now, but I mean, it certainly is
I
feeling
just
a little
think of
bit.
Aristide Zolberg's quote that the Quota X wanted to make migration disappear, right? As a sort of as a near zero. But I defer to everyone else's historical judgment over my own.
Well, Professor Kenny, you want to get in as well?
Yeah, I'm sure some people would like to make immigration go away. I don't think it will. Uh, Let me just point to some broad continuities and changes, some differences and similarities. The term nation of immigrants is under scrutiny on the left as well as the right. People don't especially like that term. So if we don't use the term nation of immigrants, we need we need another term to capture why more people have come to this country, the United States, from more places than any other country in history, right? So the United States has attracted lots and lots of immigrants. Lots of immigrants still want to come here. So whatever we want to call that, the United States was a nation of immigrants, a nation of slaves, a nation of indigenous conquest, a nation of exclusion, a nation of nativism, but it was and is an archetypal nation of immigrants in that one sense. There have been three great waves since the Republic was founded. 10 million came in the middle of the 19th century, Irish, English, German, Chinese. 26 million came in what we call the Ellis Island period. As many as 70 million have come since 1965. So we're just getting back now to the point where the foreign-born percentage, just over 14%, is roughly what it was 100 years ago. So there's a continuity there. It'd be pretty hard to cut that off. If you look at Dean Baines's slide of those 12 people, you can draw your own conclusions as to what kind of country this would be without that. There are the most significant difference, obviously, in my own work is that for the first century of the Republic, there wasn't a national immigration policy. Um, Despite that, the tensions in immigration federalism that I mapped out remain very live today. The states and local jurisdictions play a role, at least in the lives of immigrants after they arrive, potentially in Professor Morales's scenario in other ways as well.
Great. Professor Chin, you want to say anything or no? Or maybe you said something already.
No, I mean, my thought is for all of the changes in immigration policy, increased enforcement, does anybody see a real effort, a real movement to limit lawful permanent resident visa issuance, to limit the number of engineers and doctors who are allowed to come here? And I'm not sure I see it.
What's happening with the move, and you would know more about this, but what's happening with the move to try to prevent students from coming to universities? Wasn't there a recent attempt by the administration to limit those visas?
Absolutely. There was Marco Rubio said that they were going to aggressively revoke visas of Chinese students, but that seems to have been associated with the tariff policy. And President Trump had a conversation, and he issued an official tweet that said that he welcomed, that he loves Chinese students, never had a problem with them. So I think there's two things going on here. One is making the United States less attractive as a destination, which I think certainly is happening. And I think it's very unfortunate politically and economically. But the other piece is sort of formal restrictions. And I'm not sure I see that on a systematic level. Certainly part of the right-wing immigration community would like to restrict immigration, legal immigration, doctors, engineers, lawyers, computer people. But the tech bros in Silicon Valley aren't on board with that. Elon Musk isn't on board with that. I don't think President Trump is on board with that. He said historically that he would like more white European immigration, but that's different from saying that he doesn't want high-skill immigration. I think he's previously said, let's keep these people who get computer science and other STEM PhDs, let's keep them in the US.
So do you think we are in an era? Do you think, we're in a cycle? And as I'm with my chart, with the graph I showed you in terms of the, where we are in terms of number of foreign born, we're sort of like similar to where we were almost 100 years ago. Does that mean that this cycle will last as long as it did last time of like, almost 60 years, 50, 60, 70 years? Or do you think it might ebb or whatnot? What's your take on that?
So one of the things that strikes me is like we have to ask how new is everything that's going on today? Is this a radical departure from American history? And it seems to me in the panel that we've presented today that the existence of slavery and indigenous conquest and Chinese exclusion and anti-Semitism and immigration restriction and all of the things we've discussed would point to a persistent illiberal tradition in American history, of which this is a latest ugly manifestation, but a persistent tradition that has coexisted with the massive sustained immigration into the United States that we've referred to in these numbers. And to that extent, the illiberalism, the racism, the intolerance are not new, and it's not an either or proposition that you either have that or some utopian welcoming society. I think both can exist together. And so that doesn't give an answer as to when this current cycle will end, but it does suggest to me that it will. Because that illiberal tradition coexists with the economic benefits of migration, the cultural benefits of migration, and the emancipatory potential built into a country where I can claim the same right to be an American through naturalization as my children, the first of them born in Texas, automatically received at birth. That's an extraordinary thing. And I know it's under threat, but there's an awful lot to hang on to there for people around the world as well as for people in the United States.
I mean, I think one way to think about the kind of maybe the fancy word you would use to describe what Professor Kenny is saying is like co-constitutive, right? Is that in some ways, I mean, we haven't talked that much today about sort of immigration as a labor problem, right? Like I pointed in that direction with some of the comments I took from the law professor's brief and historian's brief. but there's been more work on that. And I mean, I think the sense is that sort of that labor, that base, and you hear us pointing to that now. I mean, Professor Chin's talking about doctors, lawyers, engineers, of which, you know, our scientific development is deeply and has long been deeply dependent on foreign labor. I mean, down to the Manhattan Project the last time around. And so, you know, I think I wonder, or at least can speculate, and I think there's some evidence for this, is that, you know, the demonization is one way of managing sort of the inevitability of migration and releasing stresses within the broader body politic. And I think that may be part of what we are seeing now. I mean, one way to look at what is happening now is to say, you know, we saw some charts today, right? And I tell my students this in immigration law, right? We went from a country that was 80% European immigrants to 80% from the third world, or from non-European countries, from the developing and underdeveloped world. And so, you know, that is a radical shift. It's a racial shift too, which I think everybody notes. And so I guess, I mean, another way to look at our moment is that it's been long deferred, that it's the surprising thing is actually that it's taken this long to sort of happen this way, have this sort of reaction. I think the other thing I would just point out, just because I don't ever want to concede too much to the sentiments, at least the worst versions of the sentiments being put forward in favor of certain policies being promulgated today, is I do wonder if, you know, the chart we saw earlier said after the 1965 Act, most people didn't favor immigration. And I know that some of the antics and the constant drumbeat and demonization of immigrants has had a negative effect on public opinion regarding immigration. But I do wonder if we've ever had as much support for immigrants within the body politic alongside this level of animus, right? And I don't have enough historical data at hand to sort of do a comparative, but we are of sort of two minds now in a way that seems anyway a bit different to me than in the past. And so while I think this administration's policies speak for a large percentage of the population, I don't think they speak for all of it. And in many ways, as we've seen, perhaps not even a majority on some of the most extreme policies. So I think that may be new too.
So next question, and I want to take some audience questions if we have some time, but immigrants today, because of social media and other technologies, are able to stay closer in touch with their homes, their homeland, right, in a way that they didn't before. They get to know their family members that they may never have seen. They're able to, you know, there's low cost international calling. There's just a way that my ancestors, you know, 100 years ago, just were, once you were gone, you were pretty much gone until you may have made enough money to go back and visit, but you just were gone and you were, you know, you didn't really know what was going on. It might be letters, whatever. So do you think that has played a role in the situation in terms of how immigrants are acclimating themselves in the United States, or how others perceive that they're acclimating themselves in the United States if they have this connection? Because even some countries allow people living in the United States to vote in their countries, right? So there's this real strong, the people who may be here may have a very strong attachment, stronger and reliable attachment to their home countries than they did in prior generations. Do you think that makes a difference at all?
I just want to jump in to say, I mean, one thing to think about with that comment or the question is that it also runs the other direction. That this sort of deep quote Americanization of the globe has actually increased the level to which people are pre-assimilated. And this is kind of a term in the literature. And I think this is sort of like a more of a sociology literature. But there's actually sort of evidence anyway that compared to prior waves of immigrants, more people come to the United States with more homology and continuity in terms of their sort of I don't know, whatever characteristics people care about with respect to assimilation. There's also very robust evidence that, for example, language acquisition has been consistent throughout American history, that like grown adults struggle if they don't already speak it, and then the second generation learns it fluently. And it's like one of the most robust findings. So I would just point that out to start, and I'm sure others can comment.
I would just mention from my own some of what I've seen. The way you started the question, Dean, is exactly right. This idea that the belief was that previously people came to America and basically disappeared from the old country. Something that I was surprised to have found is that that really wasn't as true as we maybe think it is. I mean, clearly, it's easier to communicate with your nation of origin today than it used to be. But it simply wasn't true that it was a one-way trip. I mean, people went back often. People communicated with their families frequently. A significant number of the people I've been studying brought their families over as soon as they could, often, again, through Galveston. They were in constant contact with people back home and with those previous communities. And so I think that's an important aspect of it, that to the one degree, the idea that there's just a line you cross when you immigrate and everything behind you vanishes, I mean, that was never true. And so I think as a way of maybe sort of moderating the question a little bit, I think that's an important thing to keep in mind. I was surprised by it, by the degree of mobility that existed then, as opposed to what I expected.
Appreciate that. Professor Kenny? Yeah.
Yeah, I'll just say a few things. I mean, really echoing what I'm hearing. I mean, the levels of return migration by Italians generation, I'm sorry, a century ago, Eastern Europeans were really very high, over 50%. That they came as birds of passage. Transnational Chinese families that were dictated in part by exclusionary policies were a fact of that history. My own ancestors in Ireland in the 19th century held something called an American wake when the emigrant was leaving, the equivalent of a wake for the dead, because they knew they'd never see them again. So that's very different from the Italian case, or there's no question that today it's easier to stay in touch because of transformation of technology. And transportation, it's easier to go back and forth, it's easier to touch. But even in the 19th century, one of the books I read was on the notion of the Americanization of Ireland in the 19th century through emigration, because everybody in Ireland had somebody here, and they communicate here in the United States, and they communicated in the ways that they could, which was through letters and remittances. So some of it is new, some of it is not new. Marcus Hansen, the immigration historian in the 1930s, came up partly tongue-in-cheek with the idea of the law of the third generation. The law of the third generation was that the third generation tried to remember what the second generation learned to forget, right? So the second generation is the children of the immigrants, and maybe language retention wasn't as high. But so it's easier today to have those connections. People who dislike immigrants will find any pretext or excuse they want to dislike immigrants. So they can say, oh, these people are less loyal, they're less American. You can just flip that around and say they know more about America and we know more about the world by virtue of them knowing more about the world too. So it's what you make of it.
Professor Chin, do you want to say something or no? Okay, let's move to the next question. So last question, and then we'll have a question from the audience. Will we ever get immigration reform?
Oy.
We have to, don't we?
So I'm going to say my response to that question is people say the immigration system is broken, but in some ways the immigration system is working just perfectly.
Yep.
Because it's not as though there isn't a vulnerable labor supply. There's plenty of people to work in hotels and in restaurants and in the fields. but they don't have really the ability to unionize or stand up for themselves, or demand higher wages. And so in many respects, for many constituencies, the immigration system is working just fine. Again, up until this year, yeah, I'm at the University of California, Davis, on the West Coast. We have a lot of international students. I know you all do too. You know, that was working fine. The lawful permanent, you know, we are able to get faculty members. Law firms can get lawyers from overseas. So in some ways, the system is quite functional. It's just that from the perspective of people without legal status who might be removed at any moment, it's not working. But the system obviously is not designed for them. It's designed for other people. So, you know, for that reason, the pressure for immigration reform is uncertain. It's complicated.
To distill Professor Chin's point a little bit, there was an article published by Professor Lopez over at UCLA a long time ago called "We Like Them Illegal, Don't We?" That I think quite admirable, sort of distills the point that Professor Chin is making, that deportability serves a labor disciplining function. And some of the segments I read about what the function of immigration crimes were at the time, they were designed to allow for removal when the labor became inconvenient or unneeded or needed to be managed. And in fact, historically, we have done so, right? We did a mass deportation not that long ago with Operation Wetback, as it was called. And so, yeah, I second Professor Chin's notion that maybe the immigration system is working, as disconcerting as that may be for people who think that the world needs to make logical sense.
One question from the audience at home, which I think is important. They want to talk about, they asked about birthright citizenship through executive action and how do the panelists view these efforts in the context of historical origins and intentions of the 14th Amendment, and what implications might such attempts have for immigration policy, is the question. So birthright citizenship.
Well, I wrote a paper with Professor Paul Finkelman that drew on a point made by Professor Gerald Newman at Harvard that says the 14th Amendment clearly was intended to apply to the children of undocumented, deportable non-citizens, namely the people brought here in violation of the prohibition on the slave trade. The slave trade laws provided that people brought here illegally should be taken into custody and deported to Liberia. There were open borders, except for people brought here in violation of the slave trade laws who were required to be deported. And nobody questions that the children of such persons born in the United States were covered by the citizenship clause of the 14th Amendment. And so the idea that, we didn't have immigration law back then, we didn't have undocumented people back then, so the 14th Amendment simply didn't contemplate them, didn't cover them, is, in my view, a failure to take into account the specifics of the network of slave trade laws and related immigration laws. They weren't all slave trade laws. Some of them had to do with, as Professor Kenny mentioned, Black sailors who were not enslaved. They were just Black. But there were prohibitions on them and on free Blacks and things like that. So the idea that this is an open question is advanced by people who have not taken the trouble to actually look at the development of immigration law in the 19th century.
Just to add, a little more broadly, the birthright citizenship as the definition of citizenship written into the Constitution in the 14th Amendment comes as a direct repudiation of Dred Scott, and it took a civil war to get there, right? It took the eradication of slavery to get there. The provision of birthright citizenship and naturalization written into the Constitution then in turn became really the greatest force for integrating immigrants and their American-born children into American society. So I'd quote the historian Eric Foner, who describes those provisions as American exceptionalism of the good kind, right? It's unusual in the context of global history and the world today to have so radical and egalitarian a definition of citizenship. It's surely part of what made America great, and it's under grave threat today, on spurious grounds, but under grave threat in the newspapers today. We're reading about the implications of not being able to enforce national injunctions and the potential parallels with state level determination of who is a citizen, going back to my own antebellum period, are really ominous, actually. So there's an awful lot at stake there. There's a fundamental principle of American democracy coming out of the abolition of slavery and the national immigration policy. That seems to be what's at stake.
Any other takers? Well, I think, that was really such a great piece that Professor Chin talked about, which really is looking at history and how important history is in terms of analyzing where we are today, but also law. In that is, legal history, because you undocumented cases that existed that people may not be aware of. That's definitely apt and to where we are today, and certainly in terms of whatever litigation we ultimately have on birthright citizenship. So thank you so much for sharing that with us. But that concludes our webinar for today. Let's give our panel of experts a warm round of applause. Congratulations. Thank you. It's great to be with you all and to participate in this incredible conversation where we learned a lot about different communities in the United States and their history, immigration history. So thank you so much.
Thank you all.
Thank you for doing this. Thank you.
And thanks to the
Absolutely.
audience for attending.
Absolutely. Thank you.